Aibowan, this is Social Space. Welcome you to Social Space. We welcome you to our channel. You know that we had to face the COVID pandemic situation recently, and at the moment we encounter serious economic crisis. And as a result of this economic crisis, several institutions take measures to dismiss their workers, close down their institutions, and to influence the workers to resign from the employment. As these things happens around us at the moment, I think this lesson would be very important to you. And here today we are talking about the decision of suspension of service, which is a most serious matter. Now let us consider the rules and regulations that prevail in Sri Lanka regarding the suspension of service. Actually, is there a possibility to suspend the service of a worker, and it's done with the salary or without the salary? Let us inquire about this, and we have different views on this. So now we can see as to which laws exist in Sri Lanka in relation to this matter, and we have to accurately identify as to what should be done and what should not to be done here. And when we look at this matter through the point of view of the work, it's important to the worker to know whether he or she is entitled to the salary during the suspension. And can an institution stop paying the salary during a suspension? If that is possible, in which instances? And similarly, we will also consider whether there's a possibility for an institution to suspend the service of a worker forfeiting the salary. First of all, we have to understand that the labor laws are drafted through the constitution of the country. And similarly, the laws are passed by Parliament, and there the determinations of superior courts in Sri Lanka are considered for these acts. Therefore, where do we take disciplinary actions against these kinds of workers, and how are such action taken? Actually, this is not clear for the workers of the private sector. They do not have a proper laws or instructions given through an act in this regard. Similarly, we do not have any nationally accepted and recognized standards in this regard. However, we have a precedent. What is that? That is the disciplinary procedure adopted by the government. This is including the Establishment Code. Therefore, accordingly, the government follows this establishment code, and the disciplinary procedure used by the government can be considered as a precedent for any employer. This has been drafted according to a very fair and reasonable method. And when we consider the precedent given by the establishment code regarding the disciplinary procedures, any employer can apply this even for the workers of the private sector. However, we earlier discussed about the lack of a clear law regarding the private sector workers. So you may at once think that the institution would conduct these things according to their own whims and fancies. No, it's not like that. With regard to disciplinary control, there are very important principles to be followed. I initially mentioned that there's no specific law regarding this matter for the private sector workers. Then one can think that different institutions act according to their own direction in the matter. Actually, it's not so. With regard to disciplinary control, there is a very important principle, that the principle of natural justice, and two factors are implied by this. In a certain allegation against a certain worker is being investigated, we have to listen to both of the complainant and the accused. And this listening should happen to a reasonable manner and impartial manner. That means you should not pay more attention to the complainant and less attention to the accused. It's not the way to do this. That is against the principle of natural justice. Therefore, we consider this principle as a very important principle which enables us to give equal opportunities for both the parties. And secondly, when a certain complaint is lodged against a certain accused, the complainant cannot take part in the investigation. Also, any other party which has close links with the complainant cannot take part in the investigation. This should happen through an independent party, and that is what we call the principle of natural justice. In the judicial system, we always respect this principle, and that is why we say that all are equal in front of the law, and there should be equal treatment without any discrimination. When we consider history, the services of the workers were not suspended without the salary. However, a court determination has been given in the year 2009. And this can be considered as a very important determination given by a superior court. This is regarding a person called Ajitha Pushantha. He was worked in a company in Horana. A disciplinary inquiry against him had been conducted during a year, and he was dismissed from service. The court accepts justification for the dismissal. and it was accepted as the correct thing to do. However, his service was suspended without paying any salary, and though that is right to life, that means income sources were deprived from him. An employee cannot do this. This is because an employee is a person who is committed to serve his or her employee on full-time basis. He is not engaged in any other job. So when he loses his job, all of a sudden he would face an immense psychological pressure, and the person would lose hopes regarding the job, and the person will not join any other income generating activity. And if we explain this further, in other words, arrangements for termination of service indicating the risk of future termination means the worker is discriminated by the employer. And here the court takes a decision, and the court says that this cannot happen. Therefore, the salary should be paid with the arrears payment. And this is a special occasion. And we can consider this decision as a very clear and reasonable decision given by a court to a worker. And also here another important matter has been raised by the court. The person called Ajit Upashant has engaged in some other job during the period of the disciplinary inquiry, and he has engaged in this job simply to earn some money for his living. And the authorities pointed out that this person had engaged in a job, and therefore they are not ready to pay the salary. However, here the court stated that he has the right to engage in any other job to maintain his family if the due salary is not paid to him or her. Here the court declares that the person has the ability to engage in any other job when the salary is not paid by the employer. But here the worker too has certain expectations. We will look at them. Here the workers should engage in a job without creating a conflict of interest. Here there is another important factor. In the same case, it says that a worker during his service period can engage in any other income generation activity for the betterment of his or her family without creating any conflict of interest. This is not considered as an offense. This is a very important decision. This Ajit Upashanta's case and the determination given in 2009 are very important here. True that it has been proven that an employee cannot terminate or suspend the service of a worker and cannot suspend the salary in an arbitrary manner. But this was challenged later on as well. Another case had been filed by a person called J.K. Jacotin later on against another company. This has been done in 2012. And here the Ajit Upashanta determination and many other factors were considered. And there it says that on 3 occasions the employee can suspend the service of the worker without paying any salary, and there the worker should have fulfilled at least one factor out of these 3. Here, if a related condition had been included in the letter of appointment, if such a condition is made in the letter of appointment, as per the particular letter, the employer has the opportunity to suspend the services without paying any salary, and in the second instance, they refer to a collective agreement. And if there's a condition made in this regard in the collective agreement, the services can be suspended accordingly. The third opportunity is where there is no collective agreement, there is no letter of appointment. However, as a tradition, the institution has to decide to suspend the services of the workers. If it has been a tradition which prevailed from a long time, and if they had no objection against that within the institution, it may be applied to others as well. Therefore, as a tradition, such decisions may get implemented. Also, here there is another determination. The Ajit Upashanta determination is also referred here, and going beyond the above mentioned 3 criteria and without fulfilling them, the services can be terminated by the employer without the salary, depending on a consumptive termination. This is called as a consumptive termination, and in this case, determination has been very clearly determined, and therefore, if the above 3 factors have not been fulfilled by a certain worker, and if the services of such a worker are suspended, the above can happen. 2012 Air Lanka case. As per the Air Lanka case determination given in 2012, the termination of service of the worker had been considered as making arrangements for termination of service indicating the risk of future termination. And there the worker has a right to claim for compensation, and the employer will have to pay that. And that is the most powerful determination given here. So, do we have only these 2 determinations regarding this particular matter? No, there is another determination, and this determination was given some time ago. Dhanavati Pereira and others was Takshila Waivers Limited. Dhanavati Pereira and others filed a case against another private institution, and when the charge sheet was issued to Dhanavati Pereira and others, a letter was sent by the institution at the particular moment with the responses to the charge sheet. A letter was sent by the institution informing the accused workers that a disciplinary inquiry would be conducted in due course. No date or no specific time was mentioned. The disciplinary inquiry got delayed for several months. They decided to file a case in the courts, and they requested the Labour Tribunal to hear the case, considering it as a termination of service. However, the institution was against this, and the court determination was given. The services has been suspended, no salary had been paid, and similarly, the disciplinary inquiry had not been conducted within the specified time. Accordingly, the institution had expelled their workers and they have become jobless. Here the meaning is that they ill-treat the workers and persuade them to leave. The court hears the case, and one may have doubts whether there's a possibility for the workers who have been suspended without the salary to claim any salary. Yes, that is definitely possible. This can happen through the appointment letter or a letter issued at the termination of employment. Collective agreement. If this matter is not included in a collective agreement, and if there is no such tradition in the workplace, the workers have the right to make a request from the institution. Then the institution may not continuously respond to such requests. They may not provide justifiable time for a disciplinary inquiry. There, what are the things that we can do? Through the legal framework, we have been given the right to file a case in the Labour Tribunal. Through that, we can get a certain relief. Department of Labour. Some may question whether the worker can get any relief by lodging a complaint at the Department of Labour. Here, there's a certain responsibility vested with the Department of Labour. The responsibility is to work as a lobby group to enable the implementation of the determination given by the superior courts. That means it's a responsibility to force or influence the employer to implement the decision given by the courts. So, we have to consider whether the responsibility is properly fulfilled by the Department of Labour. Therefore, the Labour Tribunal has the right to give orders in this regard. Therefore, it is better to discuss with the Labour Department first and then to come a consensus. However, if that doesn't happen, a complaint can be lodged at the Labour Tribunal and certain relief can be obtained. And here there's another important factor. Here, the company manager or property should understand that is considerably risky to follow a disciplinary inquiry to be carried out against a worker whose service have been suspended without paying any salary. That is consumptive termination. If not, we call it a termination of service on consumptive basis, and there the person may be influenced to resign. Under the disciplinary inquiry procedure, we can discuss about several very important instances. That means a disciplinary inquiry. We can take a representative to appear for us, and that this person would be paid by the employer. That means the company pays for it. But here we have a problem about the extent to which such a person can act in an independent and impartial manner. And similarly, a worker too can take a representative to appear for him or her. And these representatives are workers of the same institution. And here, the representative may be a person still employed in the particular firm. Therefore, if the court decides in this manner, and if the employer expects to prevent such happenings, and irrespective of what is contained in the letter of appointment and the collective agreement, measures should be taken to prove that a reasonable investigation had been carried out. We have to prove that a fair and reasonable investigation had been carried out. We have to prove that a fair and reasonable investigation had been carried out, and to provide that the employee should at least pay the salary of half a month. And it's better if there's a possibility to pay the full monthly salary, and even if the worker is dismissed after the disciplinary inquiry, the courts could consider whether the disciplinary investigation had been carried out in a fair manner. Therefore, we need to understand this background. Social space. This is your space. Your protection is your right. Please join with us to reach to the latest information on Socialist Face. Subscribers, press the bell icon too.